Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with crime. This video, in light of recent events in January of 2021, I want to talk a little bit about what not to do when you are out on bail on a criminal case. Bail is a situation where you get arrested, you go to court, you enter your not guilty plea, and then pending the resolution of your case, in all likelihood, the judge will impose certain conditions of your release. Bail conditions. Bail could be, where you actually have to post bail, you have to post property, a combination of the two, you go through a bail bondsman, whatever the case may be. And then the judge will likely also impose these other conditions, such as, don't drink alcohol, stay away from certain individuals. Maybe you have a curfew if your offense involves something along those lines. Maybe you're under house arrest, whatever the case may be. And far too often what we see are individuals who are out on bail, who are supposed to be on their best behavior, and then something surfaces. Then we see a social media picture of them drinking alcohol when they were ordered not to drink alcohol. And their case involves alcohol, and alcohol use and alcohol abuse. And their attorney has likely told them, hey, lay off alcohol, let's get this under control, and let's use this negative experience as a positive to get your life in order here and get some control over the situation. So the first tip is you want to stay off social media no matter what you're doing, right? You want to lay low, because understand that, cops, district attorneys, district attorney investigators, whoever, are going to be looking you up and seeing what you're doing, especially in the more serious cases. And you want to be mindful of that. So you don't want to be posting pictures of you out there partying. You don't want to be posting pictures with you out there with undesirable individuals. It's not smart. If ever the time to pump the brakes on something like that, it's when you're out on bail, when you have a pending criminal court case. Okay, so the first thing is avoid social media posts, especially of you doing things you probably shouldn't be doing out on bail, and understand that what you put out there is out there. Okay, people see it, people save it, people store it, people, get search warrants to get it. Okay, so be smart about that. And really the second main thing you could do, sort of under the bigger umbrella of listening to your attorney, is to map out a strategy with the law firm you hire and to go through that. And if they say, hey, we need letters of support, we need you to get a forensic psychological evaluation, we need you to proactively enroll in domestic violence classes or substance abuse classes or sex offender therapy, whatever the case may be, do it. Do it, because if you hire a law firm and you spend good money to hire a law firm and you trust that law firm to protect your interests, protect your future, then you have to go with the program. I'm not saying don't question it. I'm not saying, hey, can you explain why this is important? Can you confirm that this is not going to be an admission of guilt? Sure, those are great questions. But don't be overly resistant to it. Because if you hire the right firm, they are in all likelihood mapping out a strategy for you to get the best outcome possible, and for all bases to be covered no matter which direction the case goes. When we tell a client, hey, here's the name of a couple of therapists, here's the name of a couple of substance abuse counselors, get enrolled in a program by next week, we're not, hoping they do it. We're not sort of, maybe if you're up to it, if you want to get up out of bed, if you want to, take this case seriously, it's like we're telling you, do it. And that's the problem sometimes too, is sometimes you hire a law firm that's got a good reputation, that understands what they're doing, that has a history of producing these types of documents when their clients are out on bail, and then we walk into court with a client who doesn't do a thing. And more than it reflects poorly on us, and that's really not our concern in that moment, because we have that reputation to back it up, that we know what we're doing, and that we have a history of putting clients in positions to succeed. It's going to look poorly on you, the client, if you're not doing anything and everything we're asking to put yourself and your case and your future and your reputation and your job and your family life and everything that comes with a criminal court case. If we're asking you to put that at the forefront and take the case seriously, it's going to look poorly on you if you don't do it. And that's unfortunate, because then you're not going to enable yourself to get the best outcome possible. And I know that's what you want, and I know that's what you believe you deserve. You got to earn it. Like anything else in life, you got to earn it. So, two main lessons. Stay off social media, especially if you're putting stuff out there that you wouldn't want a judge, you wouldn't want a prosecutor, you wouldn't want potential jurors to see. and listen to your attorney. Map out a blueprint, no matter whether you have a first-time DUI, a first-time petty theft, or whether you're out on bail on voluntary manslaughter charges or on a sexual assault charge. Doesn't matter. The mindset needs to be the same. What can I do to maximize this time to ensure that I give my attorney and my future the best chance of success possible? So if you have any questions about what to do and what not to do if out on bail, feel free to give my firm a call, 619-295-3555.